if you have an attorney that's representing you in a judgment, debt, a lawsuit, some other type of litigation, it's important to make sure that there's no conflict of interest with that attorney to prosecuting your case to your best interest. And sometimes this conflict of interest may be subtle, maybe even accidental. It was a really good article about the fact that failing to disclose conflict of interest can constitute fraud, meaning that if an attorney takes your case and doesn't tell you that there's potential relationships they have either with the defendant in the case, other parties, or maybe even their own interest to further their firm's reputation, that can constitute fraud. And the interesting thing about this case that's mentioned, they didn't have to prove legal malpractice, right? Sometimes it's very difficult to prove or to be successful with a legal malpractice claim. But in this case, the court said that the allegations were sufficient for a fraud claim distinct from legal malpractice, meaning that the plaintiff, which is the client of a law firm, alleged that the firm made a false representation of fact that the conflict of interest returned negative results. Right? So when you hire an attorney, that attorney or that firm is going to do a conflict check. They're going to look at their existing clients, their previous clients, what industries they represent to make sure there's no conflict of interest. And even if it appears that they don't have any direct conflicts, it may be that there's indirect conflicts that may not rise to the level of legal malpractice, but could be a fraudulent misrepresentation to you that induces you to have them take your case. And in this particular instance, it resulted in losses for the client. What happened is the client was forced to settle for a lower amount than they would have gotten otherwise if the law firm that represented them didn't have this conflict. Because of this conflict, the law firm kind of pushed them into a place where they had to settle their case rather than go into full litigation or getting a higher payout, because there was some relationship between the law firm and some of the defendants in the case. So how do you prevent this from happening to you as a client? Well, if you hire a law firm, most times they're going to be ethical and honest and do a proper conflict check, and they're not going to take your case if it's obvious to them that they wouldn't be able to do it the right way. But you may also want to do your own research about the attorney in advance of hiring them. What other cases have they worked on? Look at the history of their representation in the court dockets to see what kind of clients they take. Even if there's no direct conflict with your exact defendant, if let's say there's a trend for them to represent builders versus contractors, subcontractors, and you're a subcontractor. Well, normally if they're representing the other side, they may have a bias to the type of claims that your counterparty is going to have. For example, if you're in a consumer law case, but your attorney or law firm represents businesses more often, that may not be the best fit. So there are very subtle types of conflicts, maybe not a direct conflict, maybe not fraud, maybe not malpractice, but you want a firm that matches the type of case and the legal theory that you want them to pursue. So we recommend, if you're going to hire an attorney you've not used before, or it's very important to have good results for your case, to do some research about their prior cases, their prior clients, what kind of arguments they make in cases, what their filings are like, how often they go to litigation versus settlement, how thorough do they do depositions and discovery. So this is the kind of thing you can do yourself. We have a service for an investigation we can do. But if you are going to hire an attorney for something as important as having a good result in a case, at least ask them what their opinion is about how to pursue the case. You want a firm that's very interested in taking your case. You don't want them to take your case begrudgingly. In fact, most firms don't want to take cases that really are not in their practice area, in their wheelhouse. But you want to make sure that your understanding of what they're going to be advocating for you matches how you want them to proceed. And you want them to be able to back that up with, have they ever dropped any clients in the middle of a case? Have they ever been removed from a case by a court or a judge? Have they ever had cases like yours that have been argued that they have not prevailed on? Doing some basic research in public records, all court cases are public records, you can see how the attorneys and how the firm argues cases, presents evidence, what legal theories they use, and picking a firm or an attorney that matches the way you want your expert advocate to be working for you will help you in the long run. Is it a little more work in advance? It is. You might have to spend a few hours doing some research, right? But this attorney presumably is going to be working on your case for many months, sometimes more than a year, sometimes several years. That few hours up front of due diligence on the attorney is not questioning their integrity or calling them out as being a fraud. It's just making sure that their interests match the direction you want to go. And it's good for them too, because they won't find themselves in a case that really doesn't align with the way that they want to pursue their legal practice. Some in advance due diligence on the firm and on the attorney might go a long way to help create the right kind of alignment, the right kind of working relationship and collaboration that you need with an attorney that's handling a very important financial or life decision that you need to make, that you want the right kind of partner to get the results that you're looking for.